Thank you, everybody, for being here today. We've had an amazing set of panelists, and we hope to continue that as we close out before the day ends. I think we have failed to mention that there's a reception afterwards where Professor Korn will be handing out some of his signature cocktails. So all are welcome here to attend, I think. So
Something like that, yeah.
Something like that, great. Just setting the stage again for folks who may be joining late or just getting involved. We're taking a step back to the heady days of 2023. The White House pushes out the National Cybersecurity Strategy, a call to action, pillar 2. Let's get public and private sector together to disrupt cybercrime at scale. And so what we're going to talk about today, and we want to flesh out some of these things, like maybe at times are a little bit of the harder conversations of what are the actual or perceived legal issues that may impact our ability to do that. There's been a lot of discussion today about the policy, sort of the interest in folks doing that, but we have a great panel of folks today to sort of flesh out some of those issues. And the great thing about this panel is we have folks from across industry and government, and we'll hopefully get diverse perspectives on some of those issues. And so I'll actually let my esteemed colleagues introduce themselves briefly, and then we're going to kind of jump right in it. So Luke, you want to start with you and just go down the line?
Thank you, Sean. Hi, everyone. Luke Dembosky. I'm at Debevoise in Plimpton. I co-head the cyber practice there. Been there about 8 years. And before that, 14 years in the Justice Department, starting as a line prosecutor. Started the same year that the NCFTA started in my home city, Pittsburgh. So I got to cherry pick cases there early on. Spent almost 3 years in Russia for the government at the embassy. Was at CSIPs with James, and then ultimately at the National Security Division before private practice.
And you're in Russia with the U.S. government.
Yes.
Okay.
The food was definitely better on that side.
Hi, I'm JJ Jones. I'm an assistant general counsel at Microsoft, and I'm based out in Seattle. I've been there and also working in just big tech generally and cybersecurity since about 2018. Before that, I was in private practice at some big firms here in DC. And I also served as an AUSA in the District of Maryland.
Good afternoon. My name is James Silver. I'm the acting principal deputy chief of the Computer Crime and IP section, or CSIPs. So I oversee basically the whole section. We have a chief who's above me, but we do policy, training, litigation, operations, takedowns, disruptions. Also, we have been involved in the UN cybercrime treaty negotiations. So we've been working with partners to hammer out an agreement there. I've been in the Department of Justice for about 17 years. I've also worked on the national security cyber side, and also for the Deputy Attorney General handling her cyber portfolio for a while. Thanks for having me.
Yeah, of course. And I'm Sean Farrell. I'm with Microsoft's Digital Crimes Unit. I'm an attorney who currently leads our strategy for AI and national security as it pertains to what the Digital Crimes Unit does. Spent a lot of time with the FBI and some time with AWS and Amazon before that. So we've got a lot of law students here. We're in a law school. This first question really is kind of an issue spotting one. We don't need the answers right now, but I'm going to kind of just reach out to each of you and ask, like, when we think about this, how do we come together? What are some of the legal issues you think of? And so, Luke, I think you have a diverse perspective as representing clients. And I know a lot of that's in the victim space. I think A.D. Vornger really called that out correctly, where you're coming as a victim to the government. There's sort of a set of legal issues you're going to be concerned about. In addition to that, if you have a client who says, like, hey, we really want to work with the government to disrupt these threats at scale, maybe more proactive engagement, what are the things that you think of or that you have discussed with clients that you may want to flag for them to think about?
Sure. Well, a lot of the limiters that you heard, I think, referenced on the prior panel, they tend to come up like, well, aren't our investigations going to be privileged and that sort of thing? And those of you in law school know that facts, of course, are not privileged. And so something like technical threat indicators, those types of things, the techniques, tactics, and procedures of the threat actor, or TTPs, like how they move and what their preferred X or Y, technique is, those are not going to be privileged. And so it's a pretty narrow scope of things to worry about So in terms of like what you could feed into disruptive operations, it's a lot more than people think. The other thing that comes up is timing. People will say, well, let's wait till the end of the investigation when the dust settled and we see if we're going to be sued or not, and then we'll decide to share. But the problem there is the shelf life of this information is so fast. And so when I have somebody like that, and we try to certainly steer them that way, is for a number of reasons that we can get into later. It's usually, number one, you don't have to talk necessarily to the world about the impacts to you. For your customers and your employees and people, yes, you're probably going to have to talk about the impacts as they're relevant to them. But in terms of takedown operations and making the world a better place, your North Star, if you will, I like Brian's phrase there, is all the things you can say that prevent this from happening to somebody else. And that doesn't have to include anything about what data of yours was stolen, what was in there. Like that's frankly none of their business. Again, it may be a client's business, customer's business, could be an employee's business. But what we're talking about here is what you could provide that would help others avert the attack or help the government. So whether it's sharing privately, being plugged in to a community, among like the banks, insurers, and ISAC and ISAL, NCFTA, whatever platform, that's just good and healthy. Lots of buoys in the water. And if one gets hit, to Matt's point, you're going to get probably some early warning from your private sector colleagues. And if you have open lines of communication with government, with the FBI and other partners, that's just another avenue. So predisposing, when people come predisposed, the key is to like create, for me as a lawyer, a crisis manager, open pathways and guidelines for them. Like you should be able to run with this and run quickly and early. If you don't necessarily want to go, the last thing I'll say on this point is that if you don't want to go in your own name right away, go through us, go through your counsel. Like we can say, look, we have a client, they've been hit by what appears to be an APT, or they've been hit by a ransomware attack. We anticipate being able to make a report to you, but not quite yet. But I don't want to sit on this IP address that the threat actor came from, or this piece. We frequently will so then bifurcate that so that the timing of it is still good.
I think that that framing is great, and I started prefacing this panel with this is the legal panel, but again, as especially aspiring lawyers in here, I'm assuming no. Very rarely is there just a pure black and white legal answer, especially in this space. You as an advisor are making holistic risk-based assessments for you, your clients, and whoever they are. And so we are focusing on some of the legal specifics for this panel, but it doesn't exist in a vacuum. JJ, you are a powerful attorney, powerful tech company, and you oversee actually some of the teams that actually engage in proactive threat intelligence sharing. And there's sort of business interests as well as the altruistic interests of protecting our customers, things like that. What are legal issues you think about when you're providing advice and trying to manage sort of both sides, commitments to customers, how we're operating as a company to build trust, things like that?
So I think it depends a bit on whether I'm thinking about sharing, or a client that I support wants to share information that relates to a Microsoft, or Google. I worked at Google too. But at the tech company's security vulnerability or an incident that's impacting the company, as opposed to, for example, TTPs, IOCs that we've so techniques and protocols or procedures that we see a threat actor doing, or other indicators of compromise that we see in just some cyber threat activity that we are tracking as essentially a security company, a cybersecurity company, and information that then might divulge other organizations or customers, for example, who have been impacted, compromised, or let's say targeted by this threat actor. Obviously, in the latter, we have to think closely about the commitments that we've made to our customers, and these can come in in a few different forms, right? You know, we blog, for example, Google blogs, Microsoft blogs, all these companies, CrowdStrike, Mandiant, you know, they blog about their practices and how they protect customer data. And so we want to think about what have we said, what are our customers' reasonable expectations of the confidentiality of data that we may come into contact with when we are internally tracking these threat actors and internally trying to understand what they're doing so we can protect our infrastructure. We can keep the services that they use safe and secure, whether it's their email or Azure, for example, or, you know, Google Cloud, Gmail. What's in our contracts, right? And what are our privacy statements and our privacy policies that have been made publicly available? And so, you know, these depend and they vary whether, for example, you know, you're an enterprise customer or consumer customer and which service you're using. And there can be an interesting analysis, legal analysis that we do depending on the services that are involved and the kind of customers that would be implicated. But, you know, big picture, we're thinking about maintaining trust with that customer, both consumers and enterprise. And, you know, we also are looking at the current landscape from both a privacy perspective and what our privacy regulators are expecting and demanding, what governments that are our customers are expecting and demanding in terms of the privacy and confidentiality of their data that's in our systems, and trust, right? How do we ensure that these other private entities, other governments, and individual consumers like yourselves will continue to trust Microsoft or Google or whatever tech company it is, trust us with your data. And so over time, you know, let's say, you know, 5-10 years ago, the landscape was very, very privacy centric, almost, you know, to the exclusion of security. And, you know, now we've seen much more of a focus on security expectations. And with that, we've had to, you know, in some ways rethink even what have we said, what have we committed to protect privacy to the extent that it limits us internally from doing the kind of internal tracking and analysis and threat hunting and intelligence and signal synthesis and aggregation that we want to do to protect our service, as well as what we may want to share with governments, CISA, et cetera, to help protect the ecosystem and protect other customers, other victims of these threat actors.
I think that's an interesting point, because even back when I was with the FBI, in our early days with some of these public-private partnerships, there was a lot of trepidation around messaging that we worked together. I say we at the time being with the FBI, with a private sector entity to disrupt a threat, because there were these concerns about privacy and perception. What I've roundly found is that people, again, as long as you're operating within the law and established and transparent policy, people seem to be happy with the results and want to hear stories about the government and private sector coming together to disrupt these threats. So to that point, James, you're one of the most powerful prosecutors in the world. And the White House says, form tactical cells at the NCFTA. Matt Lavinia is printing out raid jackets to hound out to private sector partners. As a prosecutor, what are some of the legal issues you think about that may impact, like, actually fulfilling this agreement? And again, I'm being a little silly. I don't know that the raid jackets were actually in the strategy. I'll defer to Chris on that. But when you're coming together as a prosecutor, are there legal issues you worry about when you're working with the private sector, and how do you manage that?
Thanks, Sean. So there are, I want to start by saying that I am very much supportive of the idea of public-private partnerships in this area. I think it's invaluable, and I'm certainly working to drive some change on this within the department. But I come to this from the perspective of having a team that is really on the, not only the disruption side, but really the dismantlement side. We have arrested hundreds of cyber criminals over the past several years. We are taking action against actors in safe haven countries and doing technical ops, but we've been to trial, I think, 8 times this year already in cyber cases alone. And so the actors that we are dealing with are, as they should be, using their constitutional rights to challenge the cases we put together and really mount a full-throated defense and attack and test the government's case. So when I think about what we're doing, which is beyond disruption, dismantlement, and really just destroying some cyber threats, it's how can they suppress our evidence? What can they do to really attack our case in a way that would hurt? So one bundle of problems that I have thought about is the idea of a judicial holding that a private sector entity becomes a state actor. The idea usually here is that the government says, "Hey, company, hey, FedEx, can you go look in that box?" And FedEx, would not otherwise have looked in the box, but for somebody with a badge telling them to. And then the court holds that, oh, you know what? FedEx wouldn't have looked in that box had it not been for the agent asking them to. That was a search, and you're a state actor, so you should have had a warrant. So whatever's in the box doesn't come into evidence. So this is one area that I think about at times, but it's not an insurmountable hurdle. It's just something where we have to think about, what do the case laws say here? The cases are mixed. There's no bright line rule. But generally, the principle I tease out of the case law that I advise my teams with is if private entities already have a reason to be doing something that is independent from government involvement, say, for example, they have a cyber threat that's impacting their systems, they want to root it out, that is a powerful fact that would often be fatal to a holding that they're a state actor. That's one area. Another one would be just making sure that we're not conferring any kind of inappropriate commercial advantage to anyone. I think that it's occasionally come across my desk where, a company wants to do something. Maybe that thing is illegal. Some part of the government, state or federal, says, go ahead and do that. We'll have an arrangement because this is of investigative value to us. And then that company takes the information maybe and sells it. That's a problematic thing because, risk accrues to everyone, but they're getting the benefit. So I think we want to structure things in a way where it's broad enough to not confer particular benefits to one firm. But we also have the ability to get the right partners in the room and get the right information from the right people. So we want to structure things in a way that is fair and mindful of how we're spending taxpayer money if we're doing that. I can briefly touch on discovery, broadening a prosecution team, and then also just the general idea of OPSEC, of operational security. You want to have, as a prosecutor, a very good idea of where information is going, who's got it, because I've seen really the fusion of cybercrime with violent crime. We tried a case this year against a gang that was performing online reconnaissance to figure out who had cryptocurrency, would then do SIM swapping, break into their houses, physically restrain them with zip ties, beat them in order to get crypto and take it from these people. They committed these robberies over several states. One of the defendants was sentenced to 40 years in prison. Cybercrime and violent crime have merged. We've seen witnesses killed with targeted killings in our cases. So, I have to think about that too. All of which is to say, those are things I think about, but this is absolutely the way to go. These are problems that we can solve and control, risks we can mitigate, because the private sector has just unique and invaluable insights. And those insights with our authorities is really the match made in heaven for addressing this problem and getting better at this.
So there's been a lot of talk today about, technological companies and sort of the telemetry and data that they may have. That also introduces another interesting sort of legal issue potentially when we're talking about things like the Electronic Communications Privacy Act, and which actually limits and has limitations as well as exceptions for how private sector can share information with the government. James, kicking it back to you real quick. So now where we sit now, are there any other laws or any things that people should be aware of that help enable sharing in the context of cyber threats that may help mitigate some of those concerns, and any points about that? Because it doesn't overcome a constitutional concern, as you already pointed out, from a statutory perspective.
Yeah, absolutely, Sean. So in the Electronic Communications Privacy Act, or ECPA as we call it. It's section 2702 that sets out those exceptions to the prohibition on sharing. And some of them are quite robust, and some of them go to a circumstance where a provider wants to share something because of damage that's occurring to its own system. So that's one authority. We also have in the department the Attorney General's guidelines for domestic operations and also victim and witness assistance. The witness assistance was actually rewritten quite extensively about a year or two ago. Those direct us to look into ways to share with the private sector. Obviously, CISA, the statute, not the agency, but the statute CISA is a powerful vehicle for authorizing the sharing of cyber threat indicators and defensive measures. The definitions of those two things are somewhat narrow, but I think there is, if you examine them, there is quite a bit of room to especially share information that can help network defenders to identify something and to look at a threat, to look at a vulnerability. We have, I think, internal discussions about how broadly those apply, but they're powerful tools there for us. The Privacy Act, the Patriot Act, especially Section 314B, which really figures into the cases we work that involve financial crimes, because that statute really encouraged private sector information sharing within the financial industry. And I think that industry has perhaps more of a history of sharing. And so I think that is somewhat of a model that we can look to. The network of mutual legal assistance treaties we use to obtain information from foreign countries, they all differ. They aren't all the same, but they're going to have provisions that may allow onward sharing, or we can go back and ask the country again, hey, can we share this information we got previously? We've just negotiated a new treaty that is set to go before the whole UN later on that will also have robust provisions. And then lastly, I would say the terms and conditions of providers, I think, are also a source of authority, and they differ in that some providers will say, hey, if you use my services in a way that violates our terms and conditions or violates law, in our opinion, all bets are off. We may share your information with law enforcement. And so I think that's really important because it creates a consent aspect to this. And if you look at the recent, I promise I'll stop soon, the recent Fifth Circuit opinion in Smith, which I can get to later on, the court looks at consent before it says that geofence warrants are unconstitutional. That's a separate can of worms, but it shows you how the courts are looking at the terms and conditions of the providers when they do constitutional analysis to think about privacy. And so I think that's part of the scheme of authorities we look at.
I think it's one of the great things about the law is you take a step back and just look at this level. Usually if somebody's doing something they shouldn't be, there's a law that says you can't do that or shouldn't do that. Usually if there's things that should be protected, there's a law to protect that. But usually the law has exceptions that permit you to do things that are right and that you should be doing. And so our role is like to counsel, take into account the many exceptions that exist and are layered in this myriad of, complex laws protecting certain types of information. Where there's a will, there's typically a way, and it gets back to that risk-based assessment. Sort of shifting a little bit, and go to Luke on you. One thing, and this gets a little bit more into the regulatory space. And so the question I often have and think about is sort of the carrot and stick approach. So we're coming upon now, mandates for reporting cyber events, things like that. I'm just curious from your perspective, and I'm putting you in a tough spot here. I don't know if I gave you this question in advance, but you're going to do great. Are we missing a carrot to incentivize the kind of things we're envisioning here, as opposed to putting more sticks where you have to report certain things? If I'm a customer, or maybe if I'm advising a customer, hey, this is what the regulation says you have to report about a cyber event, just do that? Are we missing something to say, hey, you go further? What are your thoughts on that? I know it's a terrible question, but thank you.
No, it's a good question. I think, you can use the sticks and the carrots to get people to buy in to the carrots earlier. So I'll give you an example or two of both carrots and sticks, but these are primarily sticks. So it used to be that you could sit on your data breach for quite a long time and decide when you were going to come out and tell the world. If you were like Target or somebody, you could sit for, oh, what was it, like 6 weeks in that case, or more than that? You could sit a long time and you could decide like when you were triggered under the privacy laws. And the threat actors, we're not doing ransom and extortion tactics and aggressive things like that. So the game has changed now. Many regulators want like very early notification. The Cercia law, I think, I think it's a great idea. I just think the execution is not so great to require people to write long, gory reports in the first hours. It's going to suck a lot of wind out of the room. I think we should have done something IOC and TTP oriented for the first 72 hours and then written your gory report at the end of the movie. But instead, we're going to divert a lot of resources to those kind of things. My point is that the government requirements are driving people to do more early. On the threat actor side, threat actors are now filing SEC complaints. They have shaming sites now for years. They're doing all sorts of cheeky, social media, trash talking, writing little screeds and diatribes on their sites. You're no longer in control. You're definitely just not in the world of like Target and those old school breaches. So if that's the reality, and the regulators now no longer can be blinded by science when you get on a call with them, they all have multiple former like forensic people or government people. So they're not going to be snowed by your technical talk either. So the pivot looks like greater investment to the kinds of good things that we all know about. Yes, there's a patchwork, but it's gelling around, 8 or so areas that we all know make for good cyber. So you buy into that. Then you buy into the idea that hopefully our clients and the regulators will understand it's not that we were breached within reason. It's not that we were breached. It's how we handle it. So reputationally. So a lot of, for example, in my world, I'm on a lot of hand-holding calls with the client's customer. So the client brought us in, they brought in like a CrowdStrike or a Mandiant or somebody, and
Perhaps a Microsoft.
perhaps a Microsoft. And we're trying to shield the poor CISO and their team who are busy putting out the fire, and they don't know very much anyway. Like, we don't want them on the first 48-hour calls. But I may have to get on and say, hi, I'm Luke. I do this every day. We're putting everything in the right order. You're going to be put first, in terms of customer leaning. And this is the process. So in the music to my ears in some of those calls is when the customer whose data might have been affected is talking to the breached, vendor that they hired. A lot of them are law firms. I don't know how I got in the business of getting hired by law firms. It's like having 200 lawyers as your client is a shark fest. But so you're on with their client, and the client says something at the end of how you've handled the call. The client has handled the call on your advice because you have no control. Like, I can't dictate that. I can only offer that we should come transparently and forthrightly. To hear you went into this call with a certain amount of goodwill, vendor, you've come out of it actually with more goodwill. Yeah, we're pissed that you lost our data, and we'll talk about like the indemnification clause in the agreement, but we are happy because we found out something about your character in this call. And hopefully that the whole world has changed in a way where the pressures have shifted. The mentality of the world is a little bit different. Not everyone, SEC, for example, but I digress. But not everyone is bought into that. Like, some people are still in the, that mode of, if something went wrong, you must have done something terrible, or you must be completely derelict. Some people have that mentality and are not there yet. But that makes it easier for you to tell the client, look, the ship is going to sail anyway. Why not be out in front and in control? And when they say to you, did you go to law enforcement? Did you work with them? Did you share? And their person who used to work in the government is on the other side and say, yes, We went to, the lead office for this threat group. We shared, we got back valuable things. Yes, we can provide those indicators to you, which is an automatic for me in advising the client. It dovetails into more carrots to your equation there.
JJ, I had a question for you, but I saw you nodding your head. Did you have anything to add before
Well, I mean, I was nodding my head because in total agreement with Luke about a number of the things that he said. For one, right, the government's ideas, regulators' ideas that, we want these companies and we want victims filing reports about their incident, within 72 hours or 48 hours or whatever ungodly number of hours it is. I don't think, and I think most of the industry doesn't really find that to be helpful outside of, a very limited amount of information, which Luke mentioned, like the TTPs and indicators of compromise, right? And that stuff, it does matter to share that quickly because that information can become stale if you wait, for example, to the end of your investigation. But, in a big incident at one of these big tech providers, you might have 40 hypotheses about what happened to you, what caused this incident, how this particular key got into the threat actor's hand still in the first week that you're working to narrow down. That's the size of these estates. And I think that's something that regulators, they don't really grasp, is the complexity of our systems, the vastness of our data, the vastness of the ways in which our data communicates and crosses different boundaries. And so and just the pure size of the state, although most government has a lot of legacy IT infrastructure as well, and they understand how hard it is, I think, just to know all the devices that they have that are connected to their networks, right? All of the potential ways that a threat actor might have gained access to compromise, the number of users, end users, employees, for example, that they have, and third parties, suppliers and vendors that have accounts, right, to access their networks, access their data, access different data repositories. So the push to do comprehensive, even remotely comprehensive incident reporting early on, I think is ill-conceived. Outside of that, very narrow information that you might have, right? You might have some of it at that point. One thing that I've thought about, though, from a security vulnerability perspective in terms of a carrot would be, like, what if the government could indemnify tech companies to be able to force patches outside of, you probably wouldn't want to do it with your big commercial enterprises because their IT infrastructure is a bit complex. But what if we could just, as tech companies, push patches or fixes for security vulnerabilities for consumer customers, or even without an opt-in? I can think of a lot of threat activity that we might be able to really minimize if there were indemnification for that.
So it's interesting, and maybe to James on this, and back when I was with the Bureau, we first brought up the idea of the government doing that and actually cleaning up infected machines. And at the time it was like, are you guys crazy? We're never going to do that. We've actually had some success in that space from the government side. Is that correct?
That's correct, Sean. So in operations like Emotet and I think more recently Quackbot, there have been some on the national security side too. I think you have seen DOJ, FBI, also international partners using, usually it's a Rule 41B warrant to authorize the remote search of multiple computers. That authority would operate in the US. Other countries would use their own authorities. But I think typically where this has been successful is when we've had a really high fidelity understanding of the malware. And then what we're actually doing on the machine is quite tailored and surgical. The question I always have when we're gearing up for one of these is like, are you going to break any computers? How heterogeneous is the victim set here? How many different versions of Windows or whatever? It's It's usually Windows, not to throw any shade or anything. It's just, it's a popular
Jeez.
operating system.
All right.
I use it.
I'll
but-
see you guys later.
But it's are we going to break anybody's computer? And I think that typically the pivotal thing is that we have a really good understanding of the malware. The malware may have its own uninstall feature. We may just be going in and taking out a small piece of it. Maybe it only lives in memory, and so you have all these technical permutations you can work through. But I think this is a really promising solution, but I think that it goes to complex questions about the citizenry's relationship with the government. And in this country, different here than it is in other countries where people maybe don't want their government messing in their computer quite as much. And so we're very mindful of that. And so we want to be very cautious when we use these authorities.
It's a perfect segue because my next question was going to be for everybody. I want to leave time for questions from the audience and the millions of people watching online. So James, what's interesting, I don't know that a lot of people understand this, CSIPs, where you work, you're kind of the DOJ headquarters entity, but you work with U.S. attorneys' offices in the United States.
Yes.
You also work with international partners. How does I would call it cross-boundary, because even with the United States, there are different things you have to take into account. When you're a specific U.S. attorney may have a different view than the department on a specific legal issue. And so you were providing some advice earlier and sort of indications on how you think about these issues. How does CSIPs go about trying to inform or influence the U.S. attorney's offices on what the policy of the department is, and how do we abide by that and sort of enforce it at a state level, and then even internationally? Maybe that's too long of a question, but maybe start with the states. And how do you work with the states and come to a consensus view on how we analyze some of these tough legal issues that may impact a cyber investigation?
So we put a lot of energy into issuing guidance. When adverse opinions come out, we will contact all of the AUSAs around the country with a summary of an adverse opinion like the one I just mentioned, Smith from the Fifth Circuit, to educate, to give practical guidance. But we're dealing with an environment where the law differs from jurisdiction to jurisdiction. You have Chatry in the Fourth saying that the same type of geofence arrangement is constitutional, whereas the Fifth has now held it's unconstitutional. More to come there. It may go to the Supreme Court, but I think that we are trying to serve as a bridge between, on the one hand, strategic decisions being made in the Department of Justice and the White House and NSC that are looking to direct and advance national policy, but then bridging that with really an operational reality in the U.S. where you have different laws. You have U.S. attorneys' offices that are understandably very protective of their relationship with their courts, and you have individual judges with they're human beings, different perspectives and views on cybercrime and how we use these authorities. So I think it's a function of, understanding the strategy, being part of that discussion here, but then being flexible with execution, because what success is going to look like in the Eastern District of Tennessee might be different from what it looks like in New York. And so you have to be sensitive to the folks on the ground who are dealing with that reality. And to give you an example, I think when it comes to private sector partnership, we might do something like, we have data from a search warrant. We want to give it to NCFTA, but you know what? We want to give the judge a heads up. It's not legally required to do that, but we're going to do it because this judge has been great for us, but has been really kind of cautious about the idea of sharing with the private sector. So a decision to file a pleading that might not be legally required in the strictest sense, but you're flexible because that's what's going to help you get traction and do something good in that particular district. So internationally, you're dealing with a very complex array of countries. But I think that if you look at the past 10 years and our main cyber successes, you see the Dutch, the Germans, the Brits, a lot of the Western and Northern European countries, Australia, some of the East Asian nations. You see, it's all changing. You see a lot of capacity building happening, but you see the same countries really doing a lot of the heavy lifting there. But I think that group is getting larger, and I think that we have to just be sensitive to different legal schemes. Some of these countries don't have the same laws we have. They may not be able to do a dual criminality analysis and say, well, you charged money laundering conspiracy. That's not illegal here, so we have a problem. But this is where the operational collaboration and the capacity building and the diplomacy all kind of work together, because you can maybe persuade a country, hey, I think you need a new law here. Maybe it'll help us work together more, and that can lead to more successes down the line.
All right, we're gonna put a bow on this with this sort of closing question for everybody. So James previously mentioned CISA 2015, everyone's the second favorite CISA, because CISA DHS is of course our favorite. The Cybersecurity Information Sharing Act 2015 is actually up for renewal, right? And so the purpose of this panel, one of the things was focused on is like, are there real legal barriers that are inhibiting our ability to meet this call from the National Cybersecurity Strategy? I didn't hear anything that said was a red line that you can absolutely cannot, but there are things that counsel for whoever you are, wherever you have to take into consideration. If you had one wish for something maybe being updated or clarified, possibly through CISA 2015 or somewhere else, is there one thing that you think could be clarified to help all of us sort of meet that that call from the National Cybersecurity Strategy of 2015? This is a tough question, and we can take audience inputs as well.
I mean, I think the equation is that the government needs the private sector's information and consent over infrastructure that the private sector controls, but doesn't have the authority to break stuff and put handcuffs on people and seize their assets and things. I mean, yeah, I guess you could get a civil order 3 years from now or something, maybe. But the government, the government needs that, the private sector needs the government's authority to do those things. And so like where we've seen microcosms of this work, and James alluded to some of this, is in like botnet takedowns, surges on operations. There's one going now on going on now on a big pain in the butt
You can
threat, APT, advanced persistent pain in the butt, where like government has convened private sector leaders to come together and surge on a particular problem. And so like all of us within our operating orbit, whether it's like James as a prosecutor or JJ as an in-house counsel or me just advising, private sector, all of us have a certain range of discretion. Like I can't call in a drone strike, but I can like encourage the client to do X. JJ will have so much latitude to recommend things and do things within the bounds of the law. And James, if we like put our cards on the table together and coordinate our action, we can take out threats in a prioritized way. And then modeling that lets everybody say, look, that worked. Could we scale that up? Could we like create a legal framework or something around that to broaden it? That's like how I think we could go. Each time, like I was one of the people that the government would ship over, and James does this now, over to the European Cybercrime Center to coordinate operations. So like Silk Road and those kind of cases, we would have to go, and there would be like 8 countries at the time that had the laws, the technical capability, and the political will. Those 3 things is what you need, green lights on. 8 countries, and then there'd be like another 4 that like didn't have a law but could do something more limited. And then there were these people over here that didn't have political will, and that's like a don't pass go. Sorry, your government won't let you participate. We would expand that each time. Each time we went on another operation, there was a bigger set of countries in each of those spheres, and we could do a more mass operation. And then I think like you study that, like I said, and you say, we could scale this into like a legal precept. Judges get more comfortable with it. Like botnet takedowns were scary in the early days. Core Flood was like 2010 or something.
Yeah.
Game Over Zeus 2013 or whatever. The AG would look at us and say, if I let you press this button and something goes wrong, you're gone. Like, I mean, basically like, don't break anything. Now it's like, the AG may not even know about botnet takedowns. You don't have to say, but
He knows everything. He does.
he knows everything. But you get it. Like it becomes part of the fabric of how we address a threat because we've proven the case studies, and so we need better case studies and keep
Rinse and
building it
repeat
up.
scale. All right. quick, any closing remarks on either the CISA 2015 or just anything I didn't ask that I should have?
I mean, generally, I think it all comes down to trust, and I think you heard that echoed by the earlier panels as well, right? And so, if I had a magic wand, I would want the government to say, hey, if a provider, internet service provider, email, what have you, telecom, if we share your data, if we identify you as a victim of this threat activity or this threat actor to the government will not then use it to come after you, whether it's DOJ, SEC, what have you, right? That we will only use that information for purposes of defending and preventing other victims, other organizations from being victimized by the same threat actor, threat activity, threat campaign. If we could get to that kind of agreement, MOU with the government, and especially the SEC, then I think we could get to a common place of trust between the private sector and the regulators that want this data to protect other parts of the ecosystem. But short of that, I think there will continue to be significant blockers because if companies stop trusting a provider to provide the service, then they go to another service. Then that service ceases to exist. So this is not it's not a small thing for the providers. It's existential for the providers to maintain that trust.
Great, thanks, James.
Sure. I know how frustrating it is to be, I've been in the private sector and to have different parts of the government look at you differently, have different agencies with their own agendas. DOJ views the victims of cybercrime as the victims of crime. And so our mission is to treat them with respect and dignity. We understand that sometimes they're going to feel like hunkering down and also feel whipsawed. And I was in the room when, my boss's boss and the SEC, head of SEC were talking through how to work out the new rule. And, the SEC's thing is market transparency, right? That's what he was all about, just sort of saying, for centuries or decades, that's what has been the foremost thing. So they're concerned about, let's get this out there, let the investors process it. But what we've tried to do to make it easier for the private sector and make it more simple is to hammer out agreements with SEC, also with FTC, where basically there's an understanding that if a company has an incident and comes forward to law enforcement and is providing information, that will be regarded favorably in whatever happens with the regulator. And so it doesn't solve the whole problem, but we have tried to create a more user-friendly experience for the companies that are in these situations. But I think the optimist in me, to go to the other part of the question, I believe that as we have more successes with public-private collaborations against cybercrime and there's more communication about how we're working together and the successes we're achieving, I think you'll see hopefully more change, both in the government, which I'm trying to drive now, getting prosecutors to think about these issues more and take advantage of the willingness of partners to provide information. But also I think, more large providers, tech companies, developing teams like the one you guys have that are focused on threats, because not everybody has anything like that. And I think that if we had more colleagues in the private sector who are looking at their holdings, identifying crime, and finding ways to work with law enforcement to make everyone safer, it's a huge win. So I think cultural change on both sides, I'm optimistic we'll get to a better place. I think that we just need to get a few of these out there for discussion, and I think successes will increase and accelerate.
Awesome. Let's do some questions. Oh, Steve. Yes.
I have a question. So a common complaint that we hear is that from the private sector that are involved in an operational collaboration with the government is that the government doesn't share much and is asking for a lot. And I know that that in the context of a law enforcement investigation, there's a lot of information developed from a variety of sources that are quite sensitive. Source operations, federal grand jury subpoenas, search warrants, registered trap and trace, all sorts of things. And the policies and the procedures by which non-public information can be shared outside of the government is pretty strict. And there's very trodden paths for how to get that information to foreign law enforcement partners in terms of getting that approved and documented. Is it completely streamlined, and is there any room to improve for investigators and analysts how and what they can share with a private sector partner in order to chum the waters on what is known by these other parties to advance the investigation?
You might handle that one.
I'm gonna throw in one thing. Steve, in my experience, my thought is it's both like policy, law, but also culturally. Since Microsoft comes here from a position of privilege, we actually at our digital crime center, Redmond, Washington, we have representatives from the FBI, HSI, and Secret Service who actually sit there with us. We still have issues though when you go to a certain field office or work in a particular investigation or coordinating, getting information back. So I just want to say, I don't think it's just the legal or policy thing. And then James, I don't know if you had anything from the policy or legal standpoint on that.
Yeah, sure. So I think that for me, it's a question of, does the authority itself have any limitations? And then is the information inherently sensitive? Sometimes I can say, well, rather than use a subpoena, use a D order because it has no secrecy restrictions and it's an easy win. Information came from a treaty. Does the treaty say you can't use it? If it does, you can go back and get a new request in. And I mean, there are practical things we can do. It depends on the authority we used, some dynamics with the jurisdiction that's really getting the court process sometimes. But a lot of these things I think are soluble. And I think that also my sense is that a lot of the data that can really be a conversation starter tends to be things like IPs and monikers, which usually aren't going to be that sensitive. I mean, I can invent a situation where it's sensitive, but usually it's not going to be something that's super sensitive. And you can use things like NDAs, or you can build protections around this stuff. So I think I try to be flexible and find solutions. I think that we are pushing out some broad guidance on this, but I think that we're still dealing with that very heterogeneous federated system of districts and offices that literally have different laws in their circuit sometimes that are controlling what they do. But I think that we can get to a place where there's more collective comfort with sharing of information and maybe moving people away from one kind of process in favor of something that's going to help accelerate that sharing.
All right, rapid fire round. Question in the back.
Hi, I'm from the Berkeley Human Rights Center on policy program there, and both this panel and the one before really focused on private sector and government relationships. And that makes sense given the proprietary information and classified information you have access to. But more and more, we're living in a world where everything's out in the open. The amount of open source information, people are putting out there, is incredibly valuable. There's a huge amount of it that people can see. And one example is the recent indictment against GRU, how some of those guys were identified wasn't from telemetry, but from YouTube videos that they themselves had put up and that people were aware before the government was. So question is, are there efforts and openness from government to also work with academia and civil society and NGOs who could do a lot to help organize and understand open source?
Absolutely. We will take analysis from any source we can. I think that I'm trying to think of, I don't like the term pig butchering, but crypto competence scams. We're aware of these scams and how they originate from certain parts of the world. And there is a wealth of information from NGOs and nonprofits and private sector groups that inform our approach there. I think that what we often have to do is take that information and then sometimes have a conversation about, well, this is great, are you willing to testify at a trial? Because not everybody is. And then sometimes that means we have to kind of, okay, this is now, the FBI is going to kind of take it from here because we kind of bring it in. But not always. And I think we have had cybercrime cases where you have even testifying experts from security firms, spam house, shadow server. I think you see a lot of firms in that space that are even also in Europe too, that are playing pivotal roles in identifying threats and providing us with insights based on just really shrewd analysis of public information. So I agree that the world has changed in this way. We're all amazed by what like Bellingcat and these groups put together, and we're consumers of that. But I think again, because we are often going to charge, arrest, trial, we sometimes have to have that difficult conversation. Are you ready to testify and maybe be cross-examined? And that's when we kind of have to sometimes hunker down and bring things more internal.
And I'll just reiterate, and I think closing out, I think Matt Lavinia said this earlier. When I use the term private sector, I'm envisioning the whole sort of environment of civil society, NGOs. We had a recent civil action against Russian-based actors engaged in sort of influence type operations, things like that, where we had NGO ISAC join us as a co-plaintiff. So I got to be more mindful of that when I'm talking about private sector. I'm envisioning all of that, and we certainly partner. And I know the government does. Yeah,
Like we work with Citizen Lab, for example, on private sector offensive actors.
well, I think we're out of time.